Yes, Ms. Pottle.
Before I continue with my sections, in response to the question posed this morning about whether Upper Tribunal Judge Gleeson was entitled to consider the facts as they were at the time of the hearing, my lord will recall that I had thought that the judge was, but I wanted to check the position of my client just to make sure. And in fact, in Section 85.4 of the Nationality, Immigration and Asylum Act 2005, the judge is entitled to consider matters which have arisen since the date of the decision.
Yes,
so there's
thank you.
No dispute on that.
Thank you. Very helpful.
I also, during the lunch adjournment, after speaking with my learned friend, forwarded an email to your clerk, which contains the authority of AJ Angola, which deals with the question of when a court will consider an error to be material. And my learned friend and I, there's no disagreement. The judgment deals, it's a judgment of this court, and Lord Justice Sales, as he then was, at paragraph 49, says that there are two categories of case in which an identified error of law might be said to be immaterial. If it is clear that on the materials before the tribunal, any rational tribunal must have come to the same conclusion. That's the material, that is the category that I'm relying on. And the second is if it is clear that despite its failure to refer to relevant legislation, the tribunal has in fact applied the test which it was supposed to apply. But it's that first category that I'm relying on. The authority of Ali appears in the authorities bundle. I've considered, because I have gone on for quite a while, I've considered my submissions over lunch, and I don't think I need to take you to it. I think Aguiarco is the more relevant case. But for my lord's note, Ali is also a judgment of Lord Reed in the Supreme Court, and he considered how the Article 8 proportionality exercise should be carried out at paragraphs 32 and 34 of that judgment. But in Ali, there was not the happy coincidence that the law, that the rules and guidance he's considering are the same that we are. And then the next case I wanted to take my lord to was the case of Jeunesse at tab 7. Which is the Strasbourg authority. The applicant in that case remained in the Netherlands following the expiry of her leave, and she had married a naturalized Dutch citizen, and they had 3 children together, and the 3 children were all Dutch nationals as well. And the question was whether her removal from the territory would breach her and her family's Article 8 rights. And the court held that her removal would entail a violation of Article 8. And the decision is relied upon to show the expansive nature of the Article 8 assessment, which includes consideration of the immigration status of all family members. I don't think that's in dispute, and it's between us, but the specific passage that I rely upon is at paragraph 108
108.
Yes, which is page 265. So the paragraph reads, another important consideration is whether family life was created at a time when the persons involved were aware that the immigration status of one of them was such that the persistence of that family life within the host state would from the outset be precarious. It is the court's well-established case law that where this is the case, it is likely only to be in exceptional circumstances that the removal of a non-national family member will constitute a violation of Article 8. And I think my lord had the point. This case is more nuanced, of course, because there were periods where the husband did not have leave, and then he was naturalized. It's a continuum.
Surely that principle can only apply in its broadest sense if the precariousness continued unabated, uninterrupted.
Well, I think
if it was precarious at the start and then became more secure, this point falls away, doesn't it?
Well, I'm not relying on it to say that because of precariousness, the removal would not constitute a violation of Article 8. I'm not saying that this case is on all fours with Jeunesse. That's not the submission. It's just that
It's a feature.
it's a feature, precisely.
But if they had, if for example, they had met 10 years before the actual date that they met, and the extra 10 years had all been lawful, then that would undoubtedly affect the weight of the fact that in 1998 or something, or 19, whenever it was, they may have had a degree of precariousness or not. So that's what you meant when you said nuanced, isn't it?
Yes, exactly.
Thank you.
The court considers the whole period, and if there are some unlawful periods and some lawful periods, all that is relevant to the assessment. Now, I don't want to muddy the waters further, so I'm going to leave that point there.
That's a very nice way of putting it.
Yes, it is, actually, because you could see a question formulating from your left, and you decided to move on quickly. Very quickly.
I feel like we had achieved a measure, well, I had achieved a measure of clarity. Now, turning to the case of GM, which my lord had asked if I was going to turn to, I have a note in my speaking note here to say, not necessary, but I think maybe I should.
Is that before or after my lord?
Before. So to give my lord some background, GM was an appeal against a decision to allow leave to remain outside the rules. The appellant, who was initially in the UK lawfully, remained after her leave had expired. And she married a Sri Lankan national with limited leave to remain, and they had 2 children. And as a side note, after the first tier tribunal's judgment, the husband and children had been granted ILR, and the upper tier tribunal considered the appeal on the basis that they had ILR.
Right.
But in GM, the judgment was given by Lord Green.
Judgment of the court. It's judgment of the court.
Yes, pardon me. Yes, judgment of the court, but
Delivered by Lord.
yes,
Yes.
delivered by Lord Green. Pardon me. He had applied Aguiarco and Ali and set out helpful observations about the test for the application of Article 8 outside the rules. And my learned friend took my lords to those observations at paragraph 27. And at paragraph 32, Lord Green affirms that the list of relevant factors to be considered is not closed, and that is clear both from the guidance, but and also from the cases of Ali and Aguirco. The respondent doesn't take issue with that guidance given, so I don't know what my lord had in mind in particular that it would be of assistance.
Well, I just wondered whether you were going to
Quibble.
pick up
No.
any
Yes.
quibbles or more major points. No. Thank you.
And then the final authority I was going to take my word to was tab 10, Mudibo. And this case concerned a citizen of Tanzania. She'd arrived in the UK as a visitor and remained after her limited leave had expired. And she applied for leave to remain as the partner of a British citizen who was diagnosed with HIV. And the appellate case, the Article 8 case outside the rules, her case was that her partner could not work in Tanzania because of an injury he had suffered. And the court affirmed at paragraph 31 the need for the appellant to provide evidence regarding the husband's inability to work.
31. This is the paragraph you cited in your skeleton. Isn't it?
Yes, that's right. So the court says the obstacles to family life, which were said to be insurmountable, were Mr. Ali's inability to work and his inability to support himself in Tanzania, and the relative standards of medical care. It seems to me that the evidence on all these points was tenuous. There was no evidence given by Mr. Ali at all. He did not explain what work he had been accustomed to, what his skills were, and what the real obstacles to employment were for him. And there was no evidence from any quarter as to what obstacles there were to support for the couple in Tanzania, and no explanation as to what the appellant's own employment prospects were. And this further comment on the medical evidence. And I think my learned friend accepts that it is for the appellant to adduce the evidence, and it must be because the respondent plainly can't, to adduce evidence concerning the difficulties or otherwise that the appellant and her husband would face on return to India. So now I've reviewed the submissions over the lunch adjournment. The submissions that I plan to make regarding the alleged error, I think I have covered already in response to my lord's questions. The materiality of the error, I just wish to make a few points, and they are, in fact, set out in some detail in my skeleton, so I'll deal with them briefly. The appellant's use of deception to obtain her leave to remain in 2013, though it was some time ago, in my submission, the respondent is entitled to treat deception as a matter of serious concern. And my learned friend relies on the ETS guidance promulgated in 2020. And that's a document that I think he handed up this morning, but that he forwarded to the court yesterday. Guidance to deal with all the cases concerning the fraudulent ETS certificates. And my learned friend relies on it because at page 7, it makes clear that the use of a fraudulent certificate is not a mandatory ground for refusal. And this is guidance from August 2020. What I would say firstly is that, of course, that guidance wasn't in place at the time that the Secretary of State made a decision in this appellant's case. But nevertheless, the rules on suitability state that don't state that it would be a mandatory ground of refusal, but that an application would normally be refused. So I don't think there's any issue between my learned friend and I on that point. But nevertheless, the Secretary of State is entitled to view the use of deception in making an application as a matter of serious concern, and that would, in accordance with the instructions, should weigh heavily in favor of refusing the appellant's application. And as against that, the factors, the evidence which was before the upper tribunal judge was that the appellant's integration in the UK was extremely limited. Her evidence was that she did not study and did not work except for a limited time in her husband's business. Albeit my lord is right that the court must also consider the husband's life in the UK and his integration, that's correct. But the evidence regarding the difficulties faced by the couple if they had to return to India was limited and contradictory. Lady Justice Andrews held that the judge was entitled to make the finding that there was no evidence to support the husband's contention that the family disapproved of the marriage. The appellant and her husband were both born in the Punjab. They speak Punjabi, and they began their working lives in India, and they have family there. The appellant was required to provide evidence regarding the difficulties the couple would face per Medivo. And in reality, there was only limited testimony covering selective issues about their difficulties. And so in my submission, the appellant's evidence fell a long way short of establishing unjustifiably harsh consequences. And so any rational tribunal would have come to the same conclusion on the Article 8 consideration outside the rules in this issue. Can I be of any further assistance?
No, thank you.
No, thank you very much.
Thank you very much indeed, Ms. Pottle. Yes, Mr. Raza.
I'm grateful. If I may first address perhaps a peripheral observation, but it was raised by my lordship during my learned friend submissions in respect of the appellant's husband's ability to acquire ILR after 14 years' worth of absence of residence. That would have been under the old 276B of the immigration rules, which was there for individuals who had been resident in the UK unlawfully for 14 years. There is authority on the point. I've got the citation in the relevant paragraph, which deals with what that provision was.
But I think the point is that was this country's policy at the time.
Precisely.
And it was properly implemented.
Precisely. And what the authority says, a case of Khan by this court in 2016, essentially recognising it was an amnesty for individuals who had been long-term overstays within the United Kingdom, and that was the basis of the grant of ILR in 2010 for the appellant's husband. Secondly, and I think this is with respect to my submission, a key feature, and it's the approach to proportionality outside of the rules. And my learned friend in her submissions has relied upon the Supreme Court's judgment in Agiaco, and to formulate the submission that the final question in a proportionality assessment is whether or not there are exceptional circumstances or the effects of removal will be unduly harsh. If I could take the panel to the decision in Agiaco and primarily at page 155 of the authorities bundle, paragraph 39 is the final paragraph on that page.
Hold on. Paragraph 39.
Yes, my lord.
Thank you.
And here the bench will see that the questions formulated by the Supreme Court, and what was being looked at was whether or not the newly introduced rules by the Secretary of State under Appendix FM were compatible with Article 8. So that's the context within which the findings and the reasoning is offered by the Supreme Court. And if we turn over the page, firstly to look at paragraph 40, and this answers the first question: what is the correct approach to the application of Article 8 to the removal of non-settled migrants? That is answered at paragraph 40 and 41, and you will see from halfway down paragraph 41, sentence beginning ultimately, it reaffirms that we are looking at a test of proportionality. The second question, insurmountable obstacles, and this also incorporates paragraph 46, which was relied upon by my learned friend in her submissions. The question being looked at, and that's if we go back to paragraph 39, is how is the insurmountable obstacles requirement in paragraph EX.1 of Appendix FM to be interpreted prior to the 2014 changes to the rules? Is it in accordance with Article 8? Now, that passage is important for two reasons. First of all, when it refers to prior to the 2014 changes, it's prior to the introduction of the Immigration Act and the public interest considerations under Section 117B. That's of course not the situation here. We are concerned with those considerations. But importantly, what was being looked at was the compatibility of the new rules with Article 8, as opposed to whether or not a decision would breach or infringe Article 8. And that is, my respectful submission, plainly set out in the final passages of paragraph 48, which appear at 159. And I read verbatim: the rules and instructions are therefore compatible with Article 8. That is not, of course, to say that decisions applying the rules and instructions in individual cases will necessarily be compatible with Article 8. So the rules are compatible, but the overall assessment is not defined or confined to being considered with those with simply the rules in mind. Now, we essentially now have a three-tiered approach towards Article 8, where we have the immigration rules themselves. We then have the exceptional circumstances, which is, if I could frame it this way, outside the rules, within the rules, which is the Secretary of State's policy, and then the third tier being a pure outside of the rules assessment, which will also take into account of the factors in Section 117B. And it's with that in mind, I referred the court to GM Sri Lanka, because that authority precisely deals with the situation where we are looking at, where the only argument before this court is whether or not the proportionality assessment outside of the rules is flawed. And with that in mind, if I could refer the court back to GM Sri Lanka, begins at page 221. I had earlier took this court to the 6 principles from 27 to 32, and what is on point with a question I was asked by my lordship in the earlier submissions as to what is then the test and question when we were looking at purely outside of the rules. That is, in fact, directly addressed from paragraph 46 onwards. And the submission is put far more eloquently than I put it, in terms of when I refer to the test neither being insurmountable obstacles or exceptional circumstances. but you will see from paragraphs 46 through to paragraph 54, the nuance which applies in the reference to reasonableness. If the panel wouldn't mind reading that at this stage, I think it would be of assistance.
46 to 55.
6 to 50.
Yes, 46 through to 54.
54.
And what it also addresses is the choice point and how that falls within the proportionality assessment outside of the rules.
Yes.
And in my respectful submission, what this reflects is that the question in proportionality is a proportionality assessment, a wide, broad-ranging assessment taking account of all relevant factors, and the conclusion, the question of whether or not there are insurmountable obstacles or exceptional circumstances is not determinative, and what can be relevant is a broader argument of reasonableness, which encompasses all of the other wider factors which come into play when looking at whether or not the appellant or a husband could return to India or live in India. So I respectfully submit that reliance on the Supreme Court's decision in Agyarko to suggest the contrary is with respect misconceived. Similarly, the point of precariousness in my respectful submission again is perhaps being given more time than is necessary, and I say that for the following reason: is Agyarko and Eunice in the ECHR, they are both judgments which predate the 2014 Act. And what the 2014 Act does is provide statute as to in which circumstances, on account of a party's status at the relevant time, should little weight or no weight or less weight be given to an individual's family life. Section 117 appears at page 2. Section 117B, forgive me, page 2 of the authorities bundle. And section 117b4 is the relevant consideration. And what that says is that little weight should be given to a relationship formed with a qualifying partner that is established by a person at a time when the person is in the United Kingdom unlawfully. So we now have a statute which tells us in which circumstances how somebody's status should affect the weight to be given to their private or family life. And the short answer here is the appellant was not unlawfully resident when she married. So the implication being section 117b4 does not bite against the appellant, and the tribunal were required to give the accepted family life full and proper weight.
You want to say anything about subsection 5?
Yes. My Lord, broadly, I think I can accept private life wasn't argued directly in respect of the appellant. Subsection 5 refers to private life. Subsection 4 is the relevant factor because we are talking about the family life.
Yes.
And to see an application of those principles as well, GM Sri Lanka also does that. And if I could direct the bench to page 230 of the authorities bundle, and this is paragraph 36 of GM Sri Lanka. You see here an application of those factors taking into account the later decision of Rapaya in the Supreme Court, which looked at the section 117b considerations in an appeal. Paragraph 36 ultimately confirmed the approach I am adopting here, that 117b4 is clear in what it says, and because the relationship was not formed at a time when the appellant was here unlawfully, it does not bite against her. And the precariousness argument, in my respectful submission, goes no further after that. Forgive me without regurgitating the point. The passage which addresses precariousness in Agiaco again predates the 2014 Act. So, with respect to conclude, what we have here, in my respectful submission, is the upper tier tribunal judge's determination, which, in my respectful submission, clearly does not conduct a balancing exercise. There is only reference to 2 or 3 matters in 2 short paragraphs, whereas there are a number of other features which are relevant to the overall proportionality assessment. And in my respectful submission, the error is clearly material. I'm grateful to my learned friend for citation of the authority in terms of in what circumstances the error could be said not to be material, and ultimately it's suggesting where the alternative conclusion would be perverse. And in my respectful submission, that clearly is not the case here. What we've heard, and again this is also consistent with my learned friend's submissions, there is a clear recognition that a proportionality assessment is a broad and nuanced exercise, and it is abundantly clear that the upper tribunal in this appeal simply do not comply with it. And in my respectful submission, given what I've said about the applicable features and the reference to the correct approach, it cannot be said that it would be perverse for an appeal of this nature to be allowed outside of the rules. And unless there's anything further I can assist my lordships with, those are my submissions.
No, thank you very much. Well, we'll just rise briefly and take stock of where we're up to. Thank you both.
Right?
Well, Mr. Raza and Ms. Pottle, first of all, we'd like to thank you both very much indeed for the quality of your submissions, which really have been of a high standard on both sides. So we're very grateful for that. We will reserve our judgment. We will, in the usual way, circulate a draft so that Council can alert us to typographical errors or any obvious factual errors. And at that stage, we'd be grateful if the two of you would try to agree upon a draft order and any consequential matters. If it emerges that for some reason you're completely at odds on one aspect of a proposed order, then perhaps very brief written submissions, which we'll consider. We've been provided helpfully with a list of those, I think, to whom the draft judgment should be sent. And Mr. Raza, on your side, yourself, Mr. Oppal, or alternatively Mr. Makijani. Ms. Pottle on your side, yourself, and Ms. Coleman. Yeah. All right. Well, the draft. Thank you very much, Jonathan. The draft can be circulated to them, but no further.
Sorry.
Yes.
Thought of something. Miss Coleman is my instructing solicitor. Would the court object to the draft being sent to my clients at the Home Office? My understanding is that in some cases they need to take internal action to prepare for publication.
Well, I think there need to be a named contact because we're not happy about the idea that it just goes to the Home Office,
Yes.
which, as you reminded us, is a large organisation.
Yes, that's right.
So, but if there is an individual who can take any consequential action which may be needed before formal hand down, then that name, if that please could be provided to Mr. Murray, clerk to my Lord Justice Stuart-Smith.
Certainly.
But obviously it's only going to be a short period between the circulation of the draft and the hand down, because the aim will be to have a remote hand down with no need for any further hearing. But it's a reasonable request, so just send in a named contact.
Yes.
Okay. Thank you both very much indeed.
Well, guys.